The Tennessee Pregnant Workers Fairness Act applies to employers with 15 or more employees. I'm going to cover 10 points to assist you in understanding the Act and how to comply with it. Number one, the Act imposes a reasonable accommodation obligation on covered employers so that for needs related to pregnancy, childbirth, or related medical condition. And it is a violation of the Act for an employer to fail or refuse to make a reasonable accommodation. And then number two, the defense for failure to provide a reasonable accommodation is that it constitutes an undue hardship to the operations of the employer's business. Number three, the employer may not require the employee to take leave for pregnancy, childbirth, or related medical condition, even under a leave law or the employer's policies, if there is a reasonable accommodation available that doesn't present an undue hardship. And number four, it is a violation of the Act for the employer to take any adverse action against the employee because the employee asked for or received and utilized a reasonable accommodation under the Act. Number five, reasonable accommodation really has the very similar meaning, maybe the same meaning as what we deal with under the Americans with Disabilities Act. It can involve altering the facilities where the employee works to make them accessible, altering the employee's work area or workspace, and it may deal with providing devices or other equipment to assist the employee. It may involve providing an area for the employee to express breast milk in private. And of course, I would point out this is also covered by another Tennessee law. It may involve things such as modification of food or drink policy, modification of breaks, so to make the breaks more frequent or longer or more flexible. It may require that assistance with manual labor, as well as some lifting restrictions. It may involve modifying seating so that if the employee has an area where they sit for work, that may be modified. Or if the job is one that typically doesn't really allow someone to sit down, it may require some effort to periodically allow the employee to sit down. Then the reasonable accommodation may also include a modification of the work schedule. That may involve making it flexible so the employee can attend prenatal visits. It may involve modification of the job itself, and this can include, in some circumstances, providing or creating a light duty job, and we'll discuss that in just a minute. Then finally, it may involve allowing the employee to temporarily transfer to another open position. So number six, the employer does not have to create a light duty job for the employee as part of an accommodation if the employer would not consider light duty for other employees who have a different condition that may need accommodation, or a class of employees. But the employer will do it for someone else or consider it, then the employee would have to consider creating a light duty job for the employee whose needs based on pregnancy, childbirth, or related medical conditions. The employer may ask for a medical certification in certain circumstances, such as where the employee is seeking a modification of the job, where that can include light duty work, where the employee would seek a transfer to a temporary job, or whatever the accommodation may be. It might involve time away from work. In those instances, the employer can ask the employee for medical certification. Then number eight, while the employee is trying to get this medical certification, assuming the employee is acting in good faith to get it, the employer cannot wait to initiate the interactive process, but has to initiate it immediately to determine if there is a reasonable accommodation to the medical needs of the employee that are based upon pregnancy, childbirth, or related medical condition. And number nine, while the employee is seeking the medical certification, as long as the employee is acting in good faith to get it, the employer is prohibited from taking an adverse action based upon the need. That is what gives rise to the request or need for accommodation. And then finally, number 10, last, a violation of the Act gives rise to a right to a civil action. So the employee may sue the employer and seek damages, and these can include back pay and compensatory damages and attorney's fees. The employee has 1 year from the date of the adverse action or termination to bring the lawsuit. So I hope these points help you understand employers' obligations under the Tennessee Pregnant Workers Fairness Act and will assist with compliance. Thank you.